This is Celebrity Court of Public Opinion.
And I'm Al Reynolds, your host and judge.
Each show, there are 4 celebrity cases, 3 real attorneys, 1 verdict, guilty or not guilty. This is Celebrity Court of Public Opinion.
Hey, listeners, what's going on? It is Monday, May the 11th, and tonight's episode, baby, it's going to be hot. It's titled Fame, Fault, and Receipts. All right, now we're having a little bit of a technical difficulty this afternoon or this evening. Our attorney Turner is dealing with her Wi-Fi, so she may be with us. She may not be with us. She may be with us sometimes. She may not be with us other times. But in any case, tonight, one case, we're going to be talking about when does a tragedy become legal responsibility? Another case we're covering tonight will be who owns your face when your face makes money. All right, our third case is one situation turns a backyard moment into a lawsuit that could cost millions. And the last case that we're going to cover reminds us just because something makes headlines does not mean it survives in court. Now, here's the problem. The law needs proof, but here in Celebrity Court of Public Opinion, proof, poof. All we need is feelings. And tonight we're going to see which one wins, because in the court of public opinion, it's how we feel, what we think, and what the perception is around the story. Now, this is not a press conference. This is not spinning. This is definitely not mercy. But what this is the Celebrity Court of Public Opinion, where I bring the pressure, my attorneys bring the law, and the jury, yep, that's you. You bring the verdict. I'm Judge Al Reynolds, and tonight, let me tell you, this docket is quite filthy. But before we get started in tonight's legal foolishness, please do me a favor. Please hit that like button. Don't forget to hit that subscribe button. If you've already subscribed, be sure to hit that share button and invite some friends over to enjoy the show. Don't forget to turn on your notifications the way I taught you how. Look right here under notifications. Go down to all, highlight all, so that we can send you a notification when the new show is about to start, which is going to be on Mondays and Thursdays at 9:30 p.m. All right, and get in that chat right now, because you know we love it when you chat us up. Based on what you just heard, now tell me, based on what you just heard, which case already sounds guilty and which one sounds like a setup? Don't think about it. Don't lawyer it up, and don't clean it up for LinkedIn. Give us your first messy instinct, because tonight we're going to find out if your gut survives the law. All right, you know I can't do this alone tonight. I have my legal beagles joining me tonight, and tonight I think I may have Sean Carter, Shatan Turner, and Kristen Weiss, counselors. Counselors, welcome back to Celebrity Court.
Glad to be back, Your Honor.
All right, counselors, I need you to give the jury the legal vocabulary so that they can drag these people accurately in the comments. So I need you to teach and lawyer them up real good. Tonight I want clarity, but in conjunction with the clarity, I need some shade. But maybe I'll bring the shade. You just bring the law. And if anybody starts tap dancing, remember, I'm definitely going to cut in. Now, listen, everybody, tonight is about fame. It is also about fault, money, ego, and receipts, because when celebrities get sued, the lawsuit is never just about the law. It's about the brand, and it's about the backstory. Now, everyone discussed tonight is presumed innocent in a court of law. Allegations are not convictions, and civil lawsuits are not criminal findings. But here, we examine the facts, but we look closer at the optics and all of the foolishness, and we decide who's guilty and who's not guilty. Court is now in session. All right, first up, let's talk about this story that just keeps on living. Yep, let's talk about Alec Baldwin. Now, Alec Baldwin, because this Rust, that's the name of the movie, is Hollywood's tragedy that will not leave the building. Now, a judge recently ruled Baldwin must face civil trial in a lawsuit from Rust because the lighting guy, Serge, who claims emotional distress tied to alleged negligence after the fatal shooting of the cinematographer Hutchins. Now, the court reportedly allowed negligence and emotional distress claims to move forward, while other claims were now. Now, here's where it gets messy. Now, we all know Alec Baldwin is not walking into public opinion as this quiet, soft-spoken, low-profile, lovable actor. No, he's talented, yes. He's successful, but he's also known to be quite a little bit of a temper in the public eye. He's clashed with paparazzi. He's had explosive headlines and what I like to call "don't try me in public" energy nonstop. So when people hear negligence, they're not just hearing legal elements, they're hearing his whole reputation. And that may not be fair in court, but here in public opinion, it matters. All right, Attorney Carter, I'm going to throw to you real quick. This is what I need to know. Does Alec Baldwin's reputation make people more willing to believe he was careless before they hear one piece of evidence? Because as we know, in a civil negligent case like this, the plaintiff actually has to prove something. Talk to us, Attorney Carter.
Right. So let's be clear, all right? Because this happened a few years ago. They're rehearsing for the show, all right, for the movie, and Alec points a gun toward the camera crew, and somehow it goes off, and a bullet comes in, hits the cinematographer, and whizzes by the gaffer. The gaffer is Serge, and he's the one who's bringing a lawsuit. And he says, "Hey, I witnessed this horrible thing. The woman died in my arms, and that's not supposed to happen." And he's absolutely right. From a negligence standpoint, think of it this way. Basically, negligence is somebody done messed up. That's as simple as it is, all right? Somebody didn't do something they were supposed to do, and obviously, you're not supposed to shoot nobody on the movie set, all right? Certainly, by the way, somebody who's not in the movie. It'd be one thing if you had a gunfight scene and somebody accidentally got shot, you shoot in the camera, right? And so he said, "Hey, that's wrong here." And from a legal standpoint, you want to learn a legal term? The term is res judicata, res ipsa loquitur. And that's Latin for Ray, stop playing in my face. And what I mean by that is, this is so obviously wrong. You're not supposed to ever get shot on the movie set. They're not supposed to have real bullets on the movie set. Right. So obviously, if you tell me you didn't do something wrong, you playing in my face. Now, the messy part, like you said, is that Alec has this reputation of being a hothead. And normally that would be a problem for him, but not here. Remember, the argument here is not that he was a hothead, not that he ran around and shot anybody on purpose, not that he yelled at anybody, but that simply he was being careless. And that's and matter of fact, his reputation for being a hothead actually helps with regard to being careless.
Oh, no. Hold on, Attorney Carter. That's actually not true as it relates to this particular movie set. This movie set was very volatile, from my understanding, according to the court documents and the coverage of this. It was very hostile because he was not only the director, but he was also the producer and an actor. And he had created such an environment that people were just on pins and needles about their position and about their job and what he wanted, because they were going over due to budget restraints. Hey, listeners, drop down in the chat if you guys remember this story. I remember this quite well because I think we covered it. Shaitan, were you here when we first covered this story? So there was a lot of back and forth going on with this story that wasn't great stuff. So the question for me, Attorney Carter, to me, as it relates, he did for the first time. Well, in this particular case, the reason why there was so much confusion was when he was, tried and when he was pushed by the prosecutor, he said, "Listen, I was just an actor. I was relying on the professionals. I was relying on the prop guy. I was relying on him to go through his procedure and his call, what he was supposed to do to make sure that the gun did what it was supposed to do." But then everybody was like pushing back because they were like, "No, you actually micromanage everybody's job on the set." So what if it was that it was volatile and that people were afraid? Some people have even inferred that, they were trying to set him up because it was such volatility on the set that people weren't doing their jobs intentionally, that someone may have set that gun up and put something that was supposed to be in there because they were just sick of his stuff. I don't know. What are your thoughts about that?
Well, even let's say, for instance, he was a jerk, right? Certainly if someone set him up, he's not responsible for that, all right? Okay. But here's the problem he has. Negligence is not really the issue here, only because, remember, the guy who's suing is the guy who's not even shot, right? What is your damage that you saw someone get shot? It's not a whole lot. Now, what he is saying is that Alex intentionally inflicted this emotional stress on him and that he wants punitive damages. And to show that Alex actually went out of his way to really be a jerk here to try to make that happen. And that's hard to say. That's more than negligence. That's actually intentional infliction of emotional distress, right? I tried to ruin, basically I tried to do this. I tried to shoot you. I tried to ruin your life by this. And, think about it. They couldn't get any criminal conviction on him trying to, be for manslaughter. So it's unlikely, he's really pushing uphill a lot.
All right, bailiff. Let's see what you got for us as it relates to the criminal charges in his day in court.
A courtroom stunner in New Mexico. Good evening, I'm Nora O'Donnell, and thank you for being with us. A judge tosses out the manslaughter case against Alec Baldwin in the Rust movie set shooting. He cried into the arms of his legal team and his wife after the case fell apart just a short time ago when the defense successfully argued that the prosecution withheld evidence.
All right. Now, Jason, let's go to you. I need a real defense strategy here. So if you were his defense attorney, right? If you were Baldwin's defense attorney, who do you blame if you represent Baldwin? Do you blame the guy who the lighting guy? What do we call him again, Attorney Carter?
Gaffer.
The gaffer. Do you blame the assistant director because he was the director? Do you blame production? I mean, who do you blame in this case? I mean, isn't he the main guy that's supposed to be over everybody? Like, who do you blame?
I blame one specific person, and that person is who is called the armorer. So in this case, it's Gutierrez Reed, and Gutierrez Reed had the job. She handled the gun. She was present on set. She failed to inspect the ammunition. She loaded a live round, not a dummy, not a blank, into a prop firearm. That's an incomprehensible and inexcusable breakdown of the one thing that the armorer is on the set to do. And he was found guilty of involuntary manslaughter and was sentenced to 18 months. So look, my client, Mr. Baldwin, trusted the only person on the set whose entire job was to make sure this never happened. She failed, and now because he's the one with the face and the smile and the anger issues, he's the one on trial.
All right, Attorney Turner, let me get it from you, counselor. You're the one that usually teaches us here. Negligence in plain English. What does that mean? What are the duty? What is it? Duty, breach, causation, damages? Explain to us what they mean when they say negligence in plain English.
Attorney Carter said it best. Somebody messed up. Someone made a mistake. Negligence is about an unintentional action that causes harm. And the elements that you articulated are designed to show four kind of different parts of it, right? Duty. Did you have a duty to the person who got injured, to the plaintiff? Breach. Did you breach that duty? And then did that breach cause an injury that's compensable with money? That's what damages is. So duty, breach, causation, and damages. Under this case, it's really kind of murky. Now, I'll say that to Attorney Carter's point, when you come to work, you do not expect to see someone die, especially as a victim of being shot by a gun. Period, the end. And so under the res ipsa loquitur theory that Attorney Carter mentioned, it means the thing speaks for itself. And so if you're the plaintiff's counsel, you say, look, he came to work and someone died in his arms because they got shot, right? This is not Compton. This was a movie set. No offense to anybody who lives in Compton. But yeah, this was a movie set. Like, this is supposed to be pretend. And when ish got real, somebody died. And so I don't really care if, Baldwin personally was negligent in examining the gun. He was negligent in holding a firearm and pointing it in that direction. Now, the flip side of it, as Attorney Weiss indicated, one thing is that when you're on movie set, you're supposed to be playing pretend. It's dress up at the highest degree, right? So in essence, Baldwin will be like, I thought it was a toy. It wasn't supposed to be real. That's a really compelling argument, but I think that the dead person, is going to be the proverbial smoking gun here. And so I think this is likely going to settle. Right.
So I'm listening to you guys give me this legal jargon and I can understand it, but someone is dead here, counselor. Someone's dead here, and someone's walking away with no responsibility or accountability here. Like,
I don't know if I agree with that. Again, the armorer served 18 months in involuntary manslaughter, and just because Baldwin might not be subject to a civil lawsuit or criminal charges. That doesn't mean that you can't sue the production company, the music company, the movie company, everybody and their mother, because you, in order to shoot a film, you need insurance. And insurance is there to cover things like negligence. A simple mistake, insurance will cover. Gross negligence, maybe not. And we don't need to get into that now. But if they're just saying that they were negligent and they should have known better and they should have done things differently, there's going to be insurance. And I understand that's not going to bring this person's life back, but it will go to the family or surviving heirs.
All right. Let's go to the jury. Let's go to the jury and see what they say. Jury, drop in the chat. Is this a real negligence that you're thinking, like Attorney Weiss says? Jury, drop in the chat. Is it A, real negligence? Is it C, Hollywood safety failure? I mean, B, is it B, Hollywood safety failure? Or is it C, Alec Baldwin's reputation catching up with him? Let me repeat that. All right, A-listers, go into the chat. I need you to drop in the chat. Is it A, real negligence? Do you believe that this was real negligence? Is it B, Hollywood safety failure, meaning that there was failure in safety on this set? Or is it C, Alec Baldwin's reputation catching up with him? Drop A, B, or C down in the chat. All right, so the Baldwin case is about one question. When tragedy happens, does fame make you more responsible or just easier to blame? Now from a movie set tragedy to a pop star saying, take my face off your boxes right now, unless my check is in the mail. All right, yep. Case number 2 is about, how do you say her name? Next up, Dua, right?
Dua Lipa.
Dua Lipa.
Dua Lipa. Dua Lipa versus Samsung. And this one is delicious because it's clean, it's corporate, it's expensive, and petty in a luxury way. Now, Dua Lipa is suing Samsung for about $15 million. Now, she's alleging the company used her image without permission on a TV packaging and created the false impression that she endorsed the product. Now, the lawsuit says the image was from backstage at an Austin City Limits in 2024 and includes claims involving copyright, trademark, and public rights. Now, let me translate. Dua is not saying you used a cute picture. In fact, she's mad that that was the picture used. She's actually saying you used my face to sell your TVs and I did not give you permission. Now, that I do get it because she is fashion, she is pop. But let me go to you, Sean Carter. If I'm walking through Costco, like, let's just be honest. Mm-hmm. Well, maybe for you, this is the case. But I'm thinking, if I'm walking through Costco and I see her on a TV box, am I wrong? Am I wrong if I don't envision in my head that she's promoting this product just because I saw her on a screen? And legally, how does that support, if some people do, how does that support a false endorsement claim?
All right. So the first part is, are you wrong? No, because I got to tell you, you don't even see the box. You go to Costco, they have the big $8,000 TV, which you know is overpriced, and you look at the quality of the image, right? And unless she owned a TV at that point, you never see the box until they load it into your car. You done already spent $8,000. So right. The fact that she would argue that, no, because I'm on the box means people bought the stuff. But here's the thing is, she got DMs from people who said, girl, I saw you on that box, and therefore I decided to spend my life savings on TV. I got to tell you, you know how I like the pretty women, all right? And I'm going to give her some money because she's cute, all right? But I'm not buying TV just because she own it. Now, she's going to put it this way, not with her on it clothed. All right, she's going to be naked on it for me to think about spending $8,000 on the TV, okay? So the idea here is ridiculous, but that does not mean she doesn't have a legal right to get her money, because the bottom line is you can't put people's faces on your products for free. And here's why. Because if that was the case, everybody would have Beyonce on their fruit, on their orange juice, on fried chicken, right? And so the idea here is that basically, once you use her likeness, and normally what you do, because think about it, you always show the TV on the box and things that are on it. But believe it or not, they have to get a license from every one of those people. So if there's a football game, they got to get the NFL, they got to get Fox, they got to get everybody who's on that picture to agree to it. They should have called her. I don't know what kind of lawyers they got at Samsung, but they apparently
they got some sloppy ones. Even I know from teaching this and daggone college that you got to get that signed off. Let's go to the chat real quick. Daniel Cameron says Samsung knows they need to run her check. But Miss Dua Lipa, I don't think anyone brought that TV because of you on the box. I agree. SL Warrior said money grab. I beat the shit.
Yep.
Said Samsung is sloppy for this. They are too long in the tooth. Generally 197017 said, Lord have mercy, Attorney Carter. Where is your wife?
Hopefully she ain't watching, but you know it's true.
All right, really quickly, Jason, if you were representing Samsung, what is the defense? Was it licensed? It was incidental. There was no reasonable person thought that Dua Lipa personally approved this television. What would be the defense here? How would you clean this up, sir, since you're so good at cleaning stuff up?
So I would say, look, the TV box and the image that's on there is to promote this Excite Hits channel on Samsung TV Plus. Samsung didn't go just find a photo of her and smack it on the box to sell TVs because they don't need to do that, right? The image appeared in the context of this streaming service that is going to be there. And it's promoting a music channel that the content of her music is there. That's different than, oh, we decided we're going to use Dua Lipa. No. The other question is, who owns that actual photograph?
She does.
She does?
Yeah.
Okay.
They shot that backstage at a show before she got on stage. So unfortunately, it's hers. Yeah, they're screwed there.
So then, yes, that's an argument that she could say. She could say that's my picture. That's what. But again, this image appeared next to this music streaming channel. It's not promoting Samsung. It's promoting this music channel. And if she wants to go after someone, if I were Samsung, I'd be like, hey, that's absolutely fine. Go over after Excite Hits and go after them. And hey, if you want help, we'll help you because we only sold one extra TV because of you.
Well, allegedly, we heard that she sent a cease and desist letter, and Samsung allegedly kept using the image. So if that's the case, Attorney Turner, what can we learn from this case?
When times are hard, companies ignore cease and desist letters. I mean, they already had the boxes made. They probably are like, oh, it's going to cost too much to put stickers over them. So we'll just ignore it and take our chances. One of the interesting things about this, though, and, you know, we'll just talk about this for a quick second, has to do with the ownership of the photograph. And as Attorney Carter indicated, I guess it must have been a promotional picture taken for her by a photographer that she paid. And so she owned the rights to the picture. The reason this is going to be interesting is even if that's true, that's going to be something that's going to be proven as a piece of evidence in this case. And the reason is because I don't know if you remember, oh, you probably do, Your Honor, because you're like a pop culture phenom, and you too have been all in these streets and getting promoted. If you recall, probably about 10 years ago at the Oscars, there was a photograph that was taken when Ellen DeGeneres was the hostess. And it was in the audience and it went viral. And it had Bradley Cooper, a bunch of A-listers, and it was taken in the audience and it went everywhere. And the question became, who owned that picture? Because generally under copyright law, it's the photographer who owns the picture because it seemed to be their art. And so that's how this gets caught up sometimes when you see famous people on products that they didn't necessarily get paid for. It goes to the point that Attorney Carter was making, like they deserve to get paid for their likeness and the appearance of endorsing. But as it relates to the usage of the photograph, that's a piece of the law that we're kind of behind the times. When I was doing my research, I learned that Denmark apparently is revamping their copyright law to give individuals the right to own their faces outright, which is a material change than how our copyright law works.
So let me ask you this. Explain for us really quickly then, Attorney Turner. Tell me the difference. What would this case be about? Is it a copyright case? Is it a likeness rights case? Or is it a false endorsement case? Or do they all add up to what this case is?
It goes to the points that you were making before in terms of the elements of the case. So you have the liability piece, which is, was there copyright infringement? Was this false endorsement? was as, improper use of her likeness. You have that aspect of the case, and then you have the damages part, which is how much is it worth? Is it worth $15 million? If there wasn't any copyright infringement, if they lose on that count, well, then it goes to the other pieces, and then it gets to what the other attorneys were saying, how much was she exploited? One could argue, and I would if I was Samsung's lawyers, that she got free advertisement because she was on the boxes and they went everywhere and it promoted her music, and it's further enhanced by the lawsuit itself. That's an argument that comes to mind for me.
So let me ask you this then. So because I'm honestly, I guess you debunked that, Attorney Carter, because I was like Jason. To me, it looked like it just happened to be a picture of a screen where a show appeared. But Attorney Carter, you're saying is actually more than that. It's even though it's captured like that, that was a picture of when she was backstage somewhere, and that's just not a picture of her on a screen promoting a show of some sort.
Well, correct. But even if it is a picture on the screen, so for instance, let's say, it was a picture of the Super Bowl. You had a bunch of players there, whatever. No, my understanding is that to put that on the box, that picture on the box, you'd have to get permission from Fox or whoever broadcast the game and the NFL. And they would both have to sign off and say, we're going to let you use that. And by the way, the players themselves, you don't have to get their particular permission because they have basically a licensing agreement, an NIL agreement through the NFL. So anything that involves the players, they can just put that on the screen. But the NFL pays for that. But the bottom line is that normally you have to pay for this. And it's weird to me that you would have to do that, particularly on the box, right? But you can understand that. Think about it. If that was the case, you know how many Beyonce box cookies there'd be out there? Everybody be selling cookies with Beyonce's face on it.
Okay, so let me go back to you, Attorney Turner, real quick, because I'm being really, really cautious now. So I've done this before. I have taken a picture from the television of something that's on television, and I have posted it on my Instagram. Does that make me liable for not getting permission for taking that picture on television?
So, Your Honor, I really don't like to use real life examples on a show where it could potentially be evidence. And so, as far as I know, you've never done it, but you thought about it.
Good idea.
If you do that, you do have to be wary. Where people get into more trouble with this kind of thing is going and lifting images off of the internet and then using them as if they're their own. People think that just because Canva's easy to use, or you can put things on Instagram that you find online, that you actually don't need to get permission to use those images. And that is false. And there actually have been some lawsuits where influencers have been sued because they've used improper they used images without getting permission. And so I would encourage anybody who is a real influencer or just plays one on YouTube on a show called Celebrity Court of Public Opinion to make sure that they have permission to use the images.
All right, well said. Let's go to the jury real quick. Jury, what is this in your mind? Jury, I need you in the chat, jury, really quickly. Jury, what is this in your mind? Is it A, theft, meaning they knew what they were doing? Samsung, that is. B, sloppy marketing. They thought that they had a workaround. Or is it C, corporate arrogance? All right, let me repeat it. Jury members, A-listers, drop down in the chat. Is this A, theft? They knew what they were doing. B, sloppy marketing. They thought they had a workaround and so they wouldn't have to pay her. Or C, corporate arrogance. They knew they were wrong and they did it anyway. Drop down in the chat. Drop down in the chat. A, theft, B, sloppy marketing, or C, corporate arrogance. This is really interesting. All right. Let's see. Blaze Brown said B. He thinks it's sloppy marketing. Something tells me it's sloppy marketing too. Pisces Unicorn says corporate arrogance. Gen 40 says corporate arrogance. Oh, you guys are really thinking it's corporate arrogance. So I would think that Samsung is a little bit too wealthy and long with good lawyers to be this sloppy. I would think so too. NY Marie says it is theft. I guess it could be a form of Leandria 7140 says pay her money. All right, so Dua's case is about image, ownership, and influence. All right, I get it. I get it. All right, let's go to our next case now. From my face, your profits, to an NFL star, an OnlyFans model who got hired for a day, a backyard football lesson, allegedly, and a broken leg. Jury, buckle up because the next case is a mess with cleats. Yep, you heard me correctly. Now, this is the messiest case of the night, and it involves the one, the only Tyreek Hill. Tyreek Hill, welcome back to Celebrity Court. Our NFL superstar, known as a speed demon, a human highlight reel man on the field. He's known for leaving defenders looking like they are buffering on bad Wi-Fi, but not in this case. Off the field, Tyreek has had headlines, a lot of it dealing with women, relationships drama, personal controversies, paternity issues, and public scrutiny. So when his name gets attached to a lawsuit involving an OnlyFans model at his private home doing a football drill and a leg ends up broken, I thought it was from hot sex, but nope. According to this lawsuit, it was not. All right. The internet says we want to know what the discovery says. So here we go. Sophie Hall, an influencer and OnlyFans model, sued Hill, claiming he broke her leg doing a football drill at his Florida home. Okay, so it was outside, guys, not in the bedroom. Reports say she alleged that Hill became embarrassed after she knocked him backwards during a drill, and later charged at her with force to prove, I'm the man in this relationship. Hill's side disputed that and reportedly was saying his team argued she tripped over a dog when she broke her leg. The case reportedly settled after trial began. Now, baby, this is the reason why we're talking about it here, though, is because the trial actually began. And after the first day of trial, after that day, Tyreek and his representatives said, hey, we don't want any more. Attorney Carter, who knew that you could be in the middle of a trial and then settle? Talk to us about what's going on here and how did this happen?
Yeah. Now, as far as being in the middle of a trial, you can settle at any time, but the timing is interesting because basically, just as you said, her defense was she had gotten embarrassed. She had actually tripped him at his football camp, and so he came at her full speed and tried to knock her down. And he says, "Hey, girl, that's not what happened at all. You spent 3 days in my house. We even did the do. All right, and your leg, you were doing ooh-ah during then, but it was different. All right, it wasn't bad ooh-ah. And so, but here's the thing is, that was going to be his defense. So when she presented her case, he was going to then come and defend and say, you enjoyed this. And this is a bedroom injury, right? He never even got to that, which means something that made him say, it made his lawyers think, bruh, we're going to lose. All right. We're not going to put on our case first. We're just going to pay this money up. Right. And so I imagine maybe she came into court wearing that tight thing and that helped a lot. In Miami, that would work a lot. It worked with me. Or two, obviously, she probably threw in some tears. White woman tears will work on him, and he's sitting there looking big and black. So he probably did the right thing.
I'm just so confused. All right, so let's go to the comments. Danielle Cameron says, now listen, we all done had a night where we thought we could put both our legs behind our heads. Thank you. We win some, we lose some. All right, Danielle Cameron, you are telling on yourself. Chaos God 1989 said Hill did it. All right. Blaze Brown said 9102 said what had happened to her leg was what happened to her leg. So obviously her leg got broken somehow. Blaze Brown 9102. I'm thinking, I just don't understand. If someone can help me, and Jason, I'll come to you because this happened in your neck of the woods. I need to understand, why did it take the first day of the trial to finally get him to settle with her? Like, all of the discovery was done. All the facts had already been presented, basically. What was it that he was afraid of?
Why is everybody spinning this that he's afraid of something? I think he made tremendous progress during day one of the trial, right? She came to his home. They played around. She knocked him down. She stayed for days. She went to the doctor 5 weeks later. That's not what a victim looks like. That's what I want to get paid looks like. So I think what happened was, after a day and a half of this trial going forward and everybody, testifying, I think that what happened is the assault and battery claims, those are gone. And now this is just a simple negligence claim. And a simple negligence claim that takes place in his home, the insurance company is probably going to cover it. So the insurance company said, you knocked out the things that we won't cover. We'll cover your negligence. They probably stroked her a check for some certain amount of money and goes there. Now, here's the other thing. You got to remember, he is in a marriage and divorce proceeding case. So every single day, and if he gets on the stand and gets cross-examined, you know that his soon-to-be ex-wife's attorney is going to be sitting in that gallery, taking notes, recording, and salivating over everything that he says. So they probably shut it down for that. But again, I don't think the mere fact that he decided to settle after a day and a half means that he did anything. I think that she saw her case was weak, and she decided to take the money because she wasn't going to get anything. Made the court speechless. Thank you, Your Honor.
I'm thinking here. I think the part that I did buy of what you shared was I would not want my client talking about another sexual relation on the stand where they could use it to possibly get his ex-wife more money, or would have to end up paying her more money, because I think that's what I heard you say. That something he would say possibly on the stand and trying to defend himself or whatever could end up could end up exposing him more, and his ex would get more ammunition to kind of get more money from him, because that's what they're going back to court for. I don't know that she wouldn't get any money. I think by the time that the courts approved her to go to trial, that there was some money involved and that she was going to get something. Attorney Turner, what are your thoughts on this, being the only woman on the panel?
First of all, I used to be a cheerleader, so I'm really flexible. No, that has nothing to do with it. But no, seriously.
Just
no, I was going to what Danielle Cameron was saying, was that all of us have gotten caught up. I've never gotten injury like that. But I do think that I disagree with Attorney Weiss that she settled because she wasn't going to get any money. I think there was risk on both sides, and it was supposed to be a 2-week trial. It ended up being a couple of days. And so something happened. That's what we know. There was some material change. And when they tried to interview the lawyers, of course, they wouldn't give any details. And when they talked to Tyreek, all he said was, I'm going to Disney World. So we will never know what happened. But I think that the argument that has appeal for me is the one that says that it was done so that the insurance could pay, right? Because him paying out of pocket is one thing, but if he was able to tap into, his homeowner's insurance policy because she got injured on the lawn, and that's really what she's saying. I think this is funny. I think the lesson for the algoriters is, and I'm going to steal this from Attorney Sean Carter, men should not be trying to do horseplay with larger women because it might not work out well for them. So allegedly, what happened was after she knocked him down, he got PO'd and he charged her like she was a guy. And so the lesson for women is don't write a check that your ass can't cash, right? She was playing rough and she couldn't handle it. But then she decided to try to get some fringe benefits afterwards, I guess, if she didn't go to the doctor right away.
Well, here's the thing.
So this is my question, though. I understand that. I understand the insurance logic, but wouldn't that have been explored anyway?
Yeah, that should have been the case beforehand.
Right.
Maybe.
But there were intentional torts that were at play, and so there are carve-outs for the insurance policy. So the challenge would have been, right, contrary to popular belief, your insurance company doesn't exist to pay out everything when people want it. Right. It actually exists to protect its assets. And so as long as there was this question about whether the intentional torts were at play, it could have compromised the coverage.
This is so interesting to me. Now I'm really interested because, wow. I mean, he saved a lot of money, but I don't understand why he had to pay all the, good money a good lawyer can save you some good money, but it's going to cost you. Whoever thought of this was quite brilliant. What were you going to say, Attorney Carter?
I was going to say that the idea here is that there was nothing that was decided on that first day by the jury. There's nothing that should have changed the insurance company's mind other than the fact that they were really concerned that, that things were either going very good or very bad, but the jury hadn't ruled anything. The judge hadn't ruled anything. Right. So nothing had changed between the start of trial and that. And what's more likely, that a jury looked at this white woman crying and said, I hate her, or they looked at a white woman crying and said, where's Emmett Till?
No, I think they look at Tyreek Hill and they're like, no, it's
really Tyreek of all people.
No,
yeah, I think so.
I honestly think that somebody after the first day of coverage, I think someone, maybe a PR person or somebody said, listen, this could get very ugly because the sexual acts, the 3 days of what happened, going through all of that could really be, create some ugly situation for this other stuff that he's got going on legally. And it'd be cheaper for us to just go ahead and give this woman her $1 million and make her go away. We don't have to answer these very, graphic, testimonies. And let's just prepare for the next case.
But Your Honor, he would have controlled that, because she wasn't going to be asking those sexual questions, because her theory was she got hurt on the lawn when they were playing football, right? So she wouldn't have gone into all of those. Those details would have been part of his defense, and he could have decided to share them or not share them. So that's why I think that Attorney Weiss's point about the other charges getting dismissed and it being able to pay out in a different way has the most appeal for me, because
but why did they only figure that out? Why did they only figure that out the day of the trial is my question.
They didn't. She wouldn't have dropped it beforehand because she wanted them to show that she played hardball. So what we know is that he paid her less than she wanted, and she got more than she probably would have gotten if she didn't show that she was intended on going through trial.
All right, let's go to our jury. Jury, what do you think? A, it was a freaky accident. B, he used too much force. Or C, settlement case from the beginning. Let's try it again. Jury, what do you think? A, was it a freak accident? B, was it too much force? Or C, was it a settlement case from the beginning? A, freaky accident. B, too much force. C, settlement case from the beginning. Drop down in the chat, A-listers. What do you think? New York Marie says A, it was a freak accident. Millennia NC says C, settlement case from the beginning. Danielle Cameron says freaky accident and settlement. Generally 197071 says all three, but you guys believe that it's a settlement case from the beginning. Okay, that's very interesting. All right, settlement case from the beginning seems like that what you guys have decided on. All right, one thing that I do know that Tyreek will know, if you're famous, do not confuse private access with private consequences, because the consequences are always going to cost more. All right. Now, from a lawsuit that settled after the mess got public to Will Smith, where the headline says sexual harassment lawsuit, but the judge said, hold on, this complaint may not be built right. Bailiff, take it away. Let's see what the accuser had to say.
Hey, everybody. I just wanted to talk about something really important. Earlier this year, I was hired to be a performer on a major tour with somebody who is huge in the industry. So I was excited, proud of myself for getting the opportunity. Unfortunately, some things happened, and I can't get into the details of exactly what that was, because it's already a legal issue right now. But the reason why I'm speaking out about this is because getting fired or getting blamed or shamed or threatened or anything like that simply for reporting sexual misconduct or safety threats at work is not okay. And I know that there's a lot of other people out there who have been afraid to speak up, and I understand. And if that's you, I see you. And that's pretty much it. More updates to come soon. Thanks for listening.
All right, now our last case is involving Will Smith. Yep, Hollywood's super A-lister. And this one is tricky because the headline alone was explosive. All we saw was Will Smith. We saw sexual harassment lawsuit. And we did also see where the judge strikes key parts. Now, this is enough of blogs to start cooking, as you know, because it went everywhere. A California judge partially granted Smith's demurrer in a lawsuit filed by violinist Brian King Joseph, meaning the court found parts of the complaint legally inefficient. Now, Joseph reportedly has 30 days to amend. Smith's attorney has called the allegations false, baseless, and reckless. Now, let's talk about why this lands differently. Will Smith is not just any celebrity. This is post-slap Will. The world still sees him through the Oscar moments. Before the slap, people might have said, that doesn't sound like Will. But after the slap, people may be saying, oh, so Will does have this type of violence in him. That's a very interesting to me perspective to have around public perception. Sean, let's go to you real quick. Explain demurrer in human language. What does it mean when the judge says parts of the complaint are legally insufficient?
Well, demurrer basically is when the other side says, what you talking about, Willis? In other words, what they're saying is, even if everything you said was true, you still don't have a case. You did not make a legal case for anything. You told us some stuff, but it has no bearing on actually this case. And remember, his claims are twofold. One, he went back to his room, and there was a note in there from somebody named Stone F. And the note said, what did it say? Brian, I'll be back no later than 5:30, just us, Stone F. But he didn't have any allegations that it came from Will. There's nobody on the team named Stone F. He doesn't know where that thing came from. And then his other claim was they retaliated against me once I, told them about this. And they're like, we didn't do that at all. All right, we did that because we realized we didn't need a violin on the Will Smith Get Jiggy with It tour. All right, and he basically has not brought up enough facts that would tie anything they did to being illegal. He needs to say somebody in that group was Stone F, whether Will Smith or one of his production people, somebody had done that. And two, that in addition to that there's some evidence that they fired him for retaliatory reason, not just because they didn't want to have a violin, because they don't like blue hair, because probably Jada was probably wanting to sleep with him and Will had to get him away. Whatever it is, all right, you know how Jada get about that. But the bottom line is that
Jada got the allegedly gay man, right?
Yeah, that's gonna be a challenge for you. If you get this one, Jada, I'll give you credit because I don't think he's going that way. But y'all go ahead and y'all work it out, Will and Jada. Y'all do stuff weird.
Let me ask you this though. Something about this, I there's a couple of things here I need answers. And Attorney Turner and Attorney Weiss, you guys jump in here. Help me understand how a baseless lawsuit got this far. Number one. Number two, why would the kid who had an opportunity of a lifetime make this type of stuff up? That's number two. And three, what was he alleging the sexual harassment part? The note? Where was the sexual harassment part happening?
There was a whole thing that happened. So there was the note, and there was this bizarre description of a room setup that was suggestive that somebody was going to come back and steal his, bussy cat. Or whatever. And so that, and then there were medications in the room to treat HIV that had someone's name on it. And it appears that he believes that all of this happened because what he was going to present was evidence of him contacting hotel security and asking them to come to look at his room. And what he said was the only people who had access to the room were people in Will Smith's camp. And so that's why he was trying to tie it to them. And his allegation of retaliation is that he complained that he was going to be a victim. And the next thing he knew, he was victim of termination. And so that's why he's pursuing this.
Oh, this is juicy. Oh, this is good.
The judge said, I don't see any of that, though.
I believe him.
We didn't bring any evidence of any of that.
I think I understand that he doesn't have any evidence, but listen, I believe that somebody was about to do something. What were you saying, Attorney Weiss?
Well, I was going to say one of the things is he reported that somebody forcibly entered his room. So it wasn't like someone had a key and just opened up the door and did it. So that's one of the things. Look, where do I think he has a case? The only case he might have would be the retaliatory discharge that he reported and he was fired. And what I think happens is now this case is weak. The way it stands, it's very weak. And privately, they're all going to go to a mediation and they're going to get this done and money is going to be paid. And we're not going to hear about this case anymore because Will Smith wants to protect his name, his image, and everything else. This guy's going to make some money. But look, he made a name for himself. Nobody else in the industry is going to work with him ever again.
Yeah, that's kind of interesting. But then some people have found out who he is. Generally, 197071 says, Will and Jada stay in some mess. That's true. Colette Davis, 4454, our real estate broker, says, no face, no case. Who did what? Where is the proof? All right. Now, Miss Colette, somebody come in your hotel room with candles and all types of stuff and lube and stuff all around. You better watch out now. Essie Stone says, not another entanglement. Blaze Brown, you should be ashamed of yourself, says violin to cheeks.
Let me just say something about the idea that you could have stuff in your room. I missed last Thursday's show. All right, went to go give a speech, and guess what? When I got there was a little note, and it had a little a bottle of champagne, and it had it didn't have any lube, unfortunately.
I missed you, Sean. I sent it to your room. I'm sorry, I missed you.
But that's the point, though. Anybody could have sent that to my room, and it would not have been anybody in the group. It could have been anybody who found out I was staying there and sent it to the room, and they would deliver it. So it's not like it's your room is sacred and only Will Smith can get in. Everybody can get in your damn room.
Two things I want to clarify, though, just so that we're clear on the show. One, nobody has alleged that Will Smith actually did these things, right? So his propensity for violence in the prior Oscars really should have had no bearing here because he happened to run or be the manager of the tour. He's not the person who is allegedly involved with this almost sexual assault. The other thing for the A-listers, though, and this is a powerful point for anybody who's ever had a job, has a job, or intends to have a job. Attorney Weiss is right. This case is falling apart on the merits. However, retaliation cases are infinitely easier to make stick than the ultimate harassment case. Because all you have to prove is that you actually complained about something that was unlawful. You don't have to show that you were right about the underlying unlawful treatment. And if an adverse employment action happens as a result, like you get fired or you get docked in pay, then you can win on the retaliation claim. And that was actually a basis for Attorney Weiss's favorite case that we've talked about, the Blake Lively and Justin Baldoni. That case ultimately settled on retaliation, and the Baldoni camp made some statement about how retaliation is wrong. And so that was the part that they just couldn't get out of in that case.
Okay, well, this is what I'm going to say. Whether this was someone else, it's just, I'm going to tell you what it reeks of me. It reeks of these powerful people with lots of money feeling like that they can play in people's faces, right? That they can play in people's faces and that they can also just do whatever they want to do with them because they hired them to be a part of their tour because they're getting ready to make them super famous. They're getting ready to make them rich. They're getting ready to make them hot. And it just appears to me that there's this undercurrent in Hollywood where this just happens way too often. So I just want to be clear. I don't know that that's the case here, but if that's the case, this type of stuff has to come to an end because people shouldn't have to feel like that they have to be involved with you sexually in order for their careers to go to the next level. That's just my take on this. And it's just so much of this underbelly in hip hop, in entertainment, that I hope that this guy had some other issues going on and he made it up. But if not, people like him, there needs to be a space for their voices to be heard. I'm sorry. It's too much of this stuff going around. I know legally this is weak, but I mean, just ethnically, I mean, not ethically, ethically, this is just keeps coming up. It just keeps coming up. And I think if people start telling more in the beginning, then we wouldn't have 20 and 30 years of a P. Diddy situation. We wouldn't have 10 and 30 years of a R. Kelly situation. So I don't know what's going on here, but if that means that for us to have less of this going on, that people have to come forward and bring these lawsuits, then come forward and bring these lawsuits. That's just my opinion here. Really quickly,
you're right.
we're running out of time. I'm sorry. Yeah, really quickly because we're running out of time. Let's go to the jury. Jury, what do you guys think? What do you guys think? Do you think A, this is a real win for Will? Do you think it's B, it's a weak lawsuit? Or do you think it's C, these type of lawsuits should come forward, especially if there's some wrongdoing somewhere in the background? Let's go. A, is this a real win for Will? Is this B, a weak lawsuit? Or is it C, these type of lawsuits should come forward so that we can end all this disgusting behavior in Hollywood? What do you think, y'all? Drop down in the chat. Is it A, a real win for Will, B, a weak lawsuit, or C, a lawsuit like this should come forward so that we can get rid of the nasty apples in Hollywood? What do you think? What do you think? What do you think? Okay, New York Maria. A lot of people are saying C. Colette says B and C, a weak lawsuit. Yeah, but I think what happens in this case, just dragging the person into public opinion, in the public eye, is embarrassing enough. It's more embarrassing to Will to have to fight this in the public and in the press than it is for him to fight this in the courtroom.
I didn't know this. When I get to the Marriott next time, I want something in my room. All right. And I want some liquor in there, preferably Hennessy. But the point is that I don't want people to be afraid to send me, please send me the liquor. Don't worry, I won't sue you.
I'll do better next time, Sean. Sorry, it was only champagne.
All right, let's transition to the jury room. All right, jury members, A-listers, come on into the jury room. A-listers, jury members, tonight we've had a movie set tragedy. We had a pop star image fight. We had a backyard NFL mess, and we had a lawsuit that got legally trimmed. Now we had different cases, same questions, but what matters more, now we're going to find out who's guilty or not guilty. Come on into the legal room. We're going to find out who's guilty and not guilty in public opinion. All right, jury, it's your time to vote. Who's guilty and not guilty? First up, Alec Baldwin. Is Alec Baldwin guilty or not guilty for system failure or too much blame on one man? Drop it now. Is he guilty? Is he guilty or not guilty? Is Alec Baldwin guilty of system failure or not guilty because that's what the prop person was supposed to do? Is Alec Baldwin guilty or not guilty? Essie Stone says guilty. Blaze Brown says guilty. New York Marie says guilty. All right, Brian Simone says not guilty. All right, everybody. Sorry, Alec Baldwin, you've been found guilty. Guilty in the court of public opinion. Dua Lipa versus Samsung. Is Dua Lipa versus Samsung. Is Samsung guilty or not guilty of knowing they used that lady's appearance but didn't want to pay her? Is Samsung guilty or not guilty? Is Samsung guilty or not guilty? Donnie Calendar says not guilty. Sandra McGee says not guilty. I Be the Shit says not guilty. All right, y'all saying that no, maybe this is falling behind. Okay. Blaze Brown says guilty. SL Warrior says come forward. Brian Simone says guilty. All right, Samsung, you've been found guilty. You've been found guilty in the court of public opinion, celebrity court of public opinion. All right, next up, Tyreek Hill. Is Tyreek Hill guilty or not guilty of breaking that lady's leg? All right, is Tyreek Hill guilty or not guilty of breaking that lady's leg and not in the bedroom? Is Tyreek Hill guilty or not guilty? Jen 40 says guilty. Christine R says guilty. Essie Stun says, oh yeah, guilty. All right, Tyreek Hill, you've been found guilty. Guilty as charged in celebrity court of public opinion. And last up, everybody, jury, come on in, jury. A-listers, come on in. Will Smith. Are we finding Will Smith, regardless of what the courts are saying, is Will Smith guilty or not guilty of making that little boy feel scared? For somebody trying to take his pussycat. All right, allegedly, is Will Smith guilty or not guilty of making that boy scared that somebody was trying to take his pussycat? Christina R says guilty. New York Marie says guilty. I Be the says not guilty. Colette Davis says not guilty. Blaze Brown says guilty. All right, Will Smith, unfortunately, you've been found guilty. You've been found guilty here. in the court of public opinion. All right, closing it out. Tonight's lesson is simple. Fame simply does not protect you. In fact, it magnifies you. Alec Baldwin reminds us that when tragedy happens, people look for power, blame, and responsibility, and who has the largest wallet to get that money. Dua Lipa reminds us that a celebrity face is not free marketing. Tyreek Hill, what does he remind us? He reminds us that private mess can become public litigation. And Will Smith reminds us that every headline is not a legal victory, and every legal victory is not a reputation repair. What do you think about his reputation now? The law asks, what can you prove? But guess what? Public opinion, we don't care about that. It's what do we believe? And celebrities get in trouble when they forget both courts are open at all times. One court has judges, the others have us, and we decide who's guilty and who's not guilty. This has been Celebrity Court of Public Opinion. Be sure to hit that like button. Also, don't forget to hit that subscribe button. Turn on your notifications. And also, I forgot, but don't forget to follow us at Celebrity Court of Public Opinion. I'm trying to get to 200. Hit that follow button. Drop the next case you want on my docket. Court is currently adjourned.